The parents of a 9-year-old Kansas City Chiefs fan are threatening to sue the media company Deadspin over an article that criticized the child for wearing a Native American headdress, having red and black paint on his face. It was during a game.
Yeah, Andrew Lieb is a discrimination attorney and managing partner at the law firm Lieb at Law. Andrew, thanks for joining us again. This is a child out watching his favorite team play football game with his parents. Deadspin publishes an article and puts out a tweet with the headline, "The NFL needs to speak out against the Kansas City Chiefs fan in blackface, native headdress." Let's just start with the simple question that a lot of our viewers want to know. Do the parents have a case here, yes or no?
It's unlikely the parents have a legal case because you would have to show that it's provable false what was said about the kid. Now, its implications are terrible. The way they painted the kid is wrong. I have a 9-year-old. My kid's turning 10 on Thursday, but I can just relate to that going to sports games. It's just awful what they did, and they doubled down. But legally speaking, it's a terrible case because it seems like opinion, not provably false statements.
What about Deadspin here? I mean, they've got a potential lawsuit on their hands. How did they get out of it? I think in my first job in journalism, in which my boss said, Joe, anytime you put a kid on TV, make sure you have permission from the parents. Is this more of an ethical versus legal thing here?
Yeah, it's an ethical versus legal thing, the way I see it. I will tell you that Deadspin's doing it all wrong from a public relations perspective. This Karen Phillips, who wrote the articles, doubling down, attacking this 9-year-old again. And I have to point out that they portrayed the kid as only having blackface, although the kid's face was both black and red. And interestingly enough, they were attacking him for Native American discrimination. And it turns out the kid's of Native American ancestry. His grandfather's like on the tribal council. It's just terrible ethics. You shouldn't go after a kid. You shouldn't be doing that. But I will tell you that when you're in a public forum, like going to an arena where the kid was, I don't think that posting a picture of a minor is legally problematic. And again, I have to point out that in defamation, you have to say something false. So if they said the kid said racist things that the kid didn't say, that would be provably false. But the issue here on a legal case is that all they did was say accurately what happened. They just implied or used opinion, which is not actionable, to paint the kid in a bad light. It's a bad look by Deadspin. I'm mortified for them. I am embarrassed for Deadspin. I think they should retract the story, apologize to the kid. You never attack a kid. That's just wrong.
I see. Okay, so, I mean, Andrew, they could have shown him face on rather than, you know, you talk about, was it factual? They only showed the side. So
they may not have a lawsuit, but they got a headache.
And maybe they have a settlement. I mean, who knows? Andrew, but while you're here, I wanted to ask you about something else because you, you really focus on discrimination. Congress is thinking about lowering the bar to prove age discrimination in the workplace. I looked it up. The median House member is 58 years old. Senate, 65 years old. Laws around, sex and race and religious discrimination, pretty clear. You can't do it. It seems easier to discriminate based on age. Is Congress going to change that?
I sure hope so. It's bipartisan that they're coming up with this. They've failed before, but let me backtrack and explain to you what's going on. You have different laws about discrimination. You referenced race and sex, and that's in Title VII. We all might have heard about that. That's an employment discrimination law. But when it comes to age, it has its own law, the Age Discrimination and Employment Act. And it turns out that there was a famous case before the Supreme Court in 2009 that said, hey, listen, you need to show that age was the but-for reason for the discrimination. It can't just be a factor. If I discriminate against you, Chance, on sex, it could just be a factor and you'd have a case. If I discriminate against you on race, it could be just a factor. But there's a much higher standard for age discrimination. And did you know that 20% of people between the ages of 40 and 50 believe in that last 10-year period that they were discriminated against based on age? So it's wrong, and we need Congress to do something about it.
With that in mind, Andrew, quickly, 40-year-olds, I mean, honestly, are less agile in many ways, even more so for 60-year-olds. They have more experience, though. They're more pricey. They need employment. How can I document my case if I think I'm being discriminated against?
Well, just for my wife, I have to point out at 42, I'm very agile. I was doing my exercises, just so you know.
There was a joke somewhere.
I just have to tell you, you have to be documenting everything. We believe in contemporaneous records. And when I take a case chance, I always ask someone, do you have a witness that will sign an affidavit? Do you have an email? Just remember that when you're done or you have a problem with your employer, they may lock you out of the systems. We will send a notice called a spoliation notice. But make sure you keep records on your personal computer, at home, contemporaneously, and have witnesses. That's the key to everything in a discrimination lawsuit. Someone to corroborate your position, because they're going to deny, and they're going to say, no chance, we denied you, we fired you because you like the Rangers, which is a good reason, obviously, but that's not a good reason to fire if age is also a factor.
Okay, I'm not as agile. My back hurts all the time, Andrew. Send me your regimen. Thank you. Andrew Lieb, as always, we appreciate it.